The coin's alert is the source of all of the information that is described in this video. Additionally, I would ask that you support my channel by liking it and subscribing to it so that you can stay up to date on future XRP news as well as other cryptocurrency news in general. Take a look at this now, shall we? Ripple has delayed the payment of a penalty to the SEC in the amount of $125 million. A penalty payment of $125 million that Ripple was supposed to make will be delayed as a result of an agreement that was reached between Ripple and the United States Securities and Exchange Commission (SEC). The SEC issued an order to Ripple on August 7th requiring the cryptocurrency to pay the penalty. The business, on the other hand, made an effort to delay the implementation of the payment procedure. During this time period, the corporation suggested that a deposit of $100,000, which is equivalent to about $139 million, be made into a bank account. Ripple will not have control over this account until the case is resolved, according to the terms of the agreement. Due to this new revelation, the possibility of the Securities and Exchange Commission (SEC) launching an appeal over the Ripple case has grown. In a previous statement, Ripple CEO Brad Garlinghouse referred to the ruling handed down by the court as a vindication for the cryptocurrency. On the other hand, the fact that an appeal could be lodged with the SEC is indicative of the possibility that the litigation will require further time to be resolved. Ripple has taken a strategic step, and the decision that it has made to delay the payment of the penalty is considered to be a component of the overall financial plan that the business has developed. At the same time that the corporation is acknowledging the decision that the court made about the punishment, it is also making preparations for the appeal procedure in order to create additional room for maneuvering. The plan that Ripple has devised reflects the company's determination to meet its financial responsibilities while simultaneously preparing for the procedures that are involved in the appeal. XRP sales made by xrp+ were declared illegal by the Securities and Exchange Commission (SEC), which wanted a significant fine from the company. The SEC sought to appeal the decision. However, the court came to the conclusion that XRP did not meet the requirements to be considered a security for retail transactions. It is still possible to take into consideration the possibility of appealing to the SEC, despite the fact that this verdict has been made. Evidence that the case has not yet been resolved is shown by the fact that Ripple would like to wait until the conclusion of the appeal procedure rather than pay the penalty. The request that Ripple has made is contingent on the official approval of the court, and it is currently waiting for confirmation from the authorities. As long as Judge Analesatoris does not provide her approval, the decision to postpone the proceeding will not be regarded as being of legal standing. On the other hand, the approval of this request by the SEC has, at the very least, temporarily relieved the tension that was present between the two parties. It's true. During the year 2020, Ripple was involved in a case with the Securities and Exchange Commission (SEC). Since that time, the cases have continued to have an effect on the markets for cryptocurrencies, as well as on the interaction between regulatory agencies. During the course of the legal action, both sides are engaging in significant strategic maneuvering. The question of whether or not XRP should be considered a security has been the subject of debates for a considerable length of time over the course of the previous few years. As a result of the strategic maneuvers that Ripple has done and the security standards that the SEC has set in this particular area, the regulatory concerns that other cryptocurrency firms are facing have been brought to light. In the event that the decision that Ripple has taken is accepted, it has the potential to set a significant precedent for other cryptocurrency companies. Ripple and the SEC have consented to postpone the appeal of the $125 million penalties. As a result of the continuing dispute that Ripple Labs is involved in with the United States Securities and Exchange Commission issues, the company has submitted a letter to postpone a payment of $125 million that was ordered by a judge on August 7th. There was a suggestion that until 30 days following the deadline for appealing the decision or the resolution, 111% of the verdict, which is approximately $139 million, would be deposited into a bank account. The request made by Ripple to delay the payment beyond the predetermined deadline of September 6th has been granted by the Commission, which has indicated that it is in agreement with the request. Taking this into consideration provides the sense that an appeal is likely to be filed. At this point in time, the lengthy case has once again become a crucial moment in the regulation of cryptocurrencies, and the potential of an appeal has added yet another twist to the scenario. The CCs have reached an agreement to delay Ripple's fine of $125 million. The court has granted a stay with regard to the enforcement of the monetary element of the final decision, as shown by the most current documents that have been given to the court, in the event that no appeal is filed within the 30 days following the conclusion of the time allotted for appealing the verdict, or until the Court of Appeals renders a decision about the appeal. The stay that was imposed by the order will continue to be in place. The court ordered Ripple to deposit 111% of the penalty, which is about $139 million, into an interest-bearing account at Trust Bank while its counsel was in charge of managing the account. This was done when the attorney was in charge of maintaining the account. In addition to this, it was indicated that the defendant would continue to have possession of the property, but that they would not have any control over the amount that was placed. The court indicated in its ruling that the fund would not be released until Ripple and the SEC reached a settlement on how it will be utilized, or until additional court orders or the end of an appeal are given. Until then, the fund would remain in its current disposition. A letter was sent by Ripple to the Securities and Exchange Commission (SEC) requesting that the monetary component be delayed, and the SEC granted its approval to the request. The chance of an appeal being filed has increased, according to attorney Fred Rispoli, as a result of this new development. It was brought to his attention that the fact that an agreement was reached about the freezing of a judgment that was worth $101.1 trillion does not guarantee that there will be an appeal. It is not anything that is done to put the amount of around $139 billion that has been suggested into a trust. If the CC is being evasive to Ripple lawyers about whether or not it wishes to appeal the verdict, he continued, unless the CCC is refusing to answer the question. Although the odds have unquestionably improved, the attorney pointed out that it is still possible that if an appeal is filed in the dispute between the SEC and Ripple, Rispoli has given the impression that a decision would not be made until the year 2026. This is despite the fact that the odds have unquestionably not improved. Despite this, the impact of the situation has been greatly mitigated as a result of the Commission's action against cryptocurrency-linked exchanges and its assertion that a number of tokens are securities. There is an increasing deficiency of appeal messaging in the market, despite the fact that there are only 32 days left for the appeal and the SEC has not spoken since August 7th. As a result of the fact that Ripple Labs' legal battle with the SEC has taken yet another turn, the business has made the decision to put the penalty of $125 million until further notice. In spite of the fact that the SEC has hinted at the prospect of appealing the ruling that was handed down on August 7th, Ripple's legal team has been successful in their plea to postpone the substantial payment. Both teams are currently contemplating their next move in front of a confrontation that has the potential to dramatically alter the course of the game. There would be no complaint lodged in the near future. As a dramatic turn of events, the second update concerning Ripple is presented here. The request made by Ripple to maintain $125 million in a bank account while the Securities and Exchange Commission deliberates on its subsequent actions has been granted by Judge Torres. Ripple and the Competition Commission have the opportunity to appeal a response to the substantial finding that was made regarding XRP programmatic sales of cryptocurrency as a result of this temporary stay. The legal team representing Ripple was successful in gaining approval from the SEC to postpone the payment of the $125 million penalty until after September 6th, as stated in a document that was submitted on September 4th. The attorney proposed that a balance of $139 million, which is equivalent to $100,000, the complete amount of the judgment, be deposited into a bank account for a period of 30 days while both parties decide what steps they will take in the future. Lawyers shared their thoughts on the Sessi family's case, which has become less compelling as a result of the decision made by the court. The period of time during which prospective appeals can be filed has been extended, and Ripple and the SEC will both have the opportunity to submit their arguments. There is a possibility that the case will not be decided for a number of years if an appeal is allowed.